Yes, maybe just I'd like to mention for listing one, I actually should be come in the hearing column, but it should be mentioned in
What is the year?
2019.
Wait for something. You missed the registry. First we are fifth up to 15. Let us finish. Then we'll come back to all those matters.
Okay.
Yes.
Please, Your Lordship. I beg to mention item number 11.
Yes.
Maybe adjourned.
Yes. On the prayer of the learned council for the petitioner, matter stands adjourned.
Lordship, there's interim.
Interim order pass earlier shall continue till the next date of listing.
Much obliged.
No date. 2018. No date.
Lordship, if I may, I beg to mention item number 24, Lordship, of the daily list.
Item number?
24, Lordship. Lordship, we pray for a little more time because the petitioner here has been out of contact with us for quite a while now, and we would like to
No
rectify
issue.
his.
No issue, no problem. There is a problem between you and your client. We'll engage an amicus. Okay? Yes. Next case. So we have refused your adjournment.
Lordship, the actual issue is we're not sure as to whether the gentleman is alive.
No, we are
He
not
has
concerned.
completely gone out of contact, Lordship.
We are not concerned with that. We'll appoint an amicus and hear this matter.
Lordship.
That is your problem with your client. Yes.
Lord, petitioner is a wholesale dealer, my lord.
Hmm.
Here, they are dealing in various items, including oils, my lord.
Essential, yes.
Now, they,
Oh, Mr. Sayala,
Yes.
FIR discloses many things. Can we deal with all your documents and all at
my
this
lord,
stage?
your lordship may see that, my lord, the deputy commissioner,
Hmm.
yet, so, my lord, these VIO authorities are, my lord, behind us, my lord.
Hmm.
They wanted to, my lord, to make money. That is the difficulty, my lord, here. If your lordship will see that deputy commissioner's order,
Where is that?
my lord, that page 28 of the IPP opposition,
28.
of the IPP opposition. My lord, your lordship may skip over the first two paragraphs also
Hmm.
from third paragraph. In this context, I have gone through the detailed inquiry report as submitted by the seizing officer, right, so it's dated, and
Just a
also
minute, just
contents of the application.
28. Just a minute, 28, na? There is page up to 19.
Next are 10, my lord.
And next, sir?
10.
Page 20, Century Market. There. And next, sir, 10 of affidavit in reply.
Opposition.
Affidavit in opposition. Okay. Page 20
8.
to 8. Yes.
Third paragraph I'm reading, my lord, the others are there. In this context, I have gone through the detailed inquiry report dated so-and-so, submitted by the seizing officer by so-and-so, dated 5/3/14, and also the contents of the application dated 24/3/14, filed by the applicant company for eligible seized stock of vegetable oils on personal injury bond, including its company's time to time communications available in the relevant license file available in the office. The applicant company in the application dated so-and-so entirely submitted that on many occasions, due to lack of space in the applicant godown, they had to store some goods in other godown on temporary basis. As per the provisions or terms and conditions contained in the license, they have been informing the license authority as well as the Superintendent of Taxes about such temporary storage of arrangement, and more particularly storing articles in the Assam State Warehousing Corporation godown. Further, it is also submitted that the applicant's company has all along been sending their stock position of article in daily opening stock summary return submitted to the Food, Civil Supplies and Consumer Affairs branch of this establishment through the Kamrup Chamber of Commerce on daily basis. And the said stock of the goods have also been included in company stock register. I have also heard Kailash Kabra and Sri Prakash Chandra Kabra, both directors of the applicant company on 26/2014 in person, and examined the records produced by them in defense. In this connection, a stock verification report dated 15/5/14 regarding seized edible oil submitted by area officer of Food and Civil Supplies and Consumer Affairs branch of this establishment has also been taken into consideration in this matter. Upon careful examination of all the records, including statements of this director's applicant company, the following observation has been made. The applicant company has informed the Superintendent of Taxes about the arrival of the storage siege stock of vegetable oil in time. The applicant company is found to have informed the undersigned licensing authority on storage of goods in Assam Warehousing Corporation by their information dated 27/1/14 and 29/1/14 respectively, which was received on 31/14.
By the service.
Yes, by the office and good minister. The siege stocks of vegetable oils, so and so, liter bottles, which contains maximum retail price. The team of BIO.
Where are you reading?
My lord, next page, my lord.
By articles in shop and good on premises. Okay, the C stock.
Yes. The siege stock of vegetables and so and so contains maximum retail price. The team of BI official did not take the district administration into confidence with while conducting raid inspection in the applicant company despite state government's standing instruction, nor they felt it necessary to ascertain whether applicant company has given intimation of license to the licensing authority about the storage of the articles other than the quotas specified in the license. Rather, they acted in a preconceived mind. As per stock verification report, that 15/5/14, the verifying officer observed leakages in the few cartons and the labels inscribed on the body of the cartons indicated that the seized products are batch of number of August 2013 and November 2013, the best before 6 months. On the face of the above, I find that there is nothing malafide behind the temporary storage of the seized stock of vegetables, oils in the holding of the Assam State Warehousing Corporation made by the applicant company. And there seems to be substantial compliance with the terms and conditions of the wholesale license granted and issued to them under the provision of Assam Trade Articles Licensing Approved in 1982. I am also of the opinion that the seized stock of vegetable oils are subject to natural decay and thus it should be disposed of by sale and avoid deterioration. Therefore, it is ordered to release the seized stock of vegetable oil in our favor. I thought. Next stock. Well, here what happened? This trade articles order has been declared already ultra virus, my lord, by this court.
Where is that?
Yes, sir. 2012 4 DNT. Actually, my lord, otherwise also terms and conditions said, my lord, the condition on
This is-
72 hours I have to inform after receiving. Now, this is the judgment, my lord. Para 12, my lord, last. Declared alta virus.
So this power was exercised under this 82 orders.
My lord, yes, that's it.
Where is that 82 orders?
So what I not able to give me, my lord, presently.
Let us see the FIR
And
first.
that's it, and control order is there, my lord. I'm having. I'm
Oh.
a copy I am giving there. I've got a photocopy of that also. My lord, even if it is applicable also, we have to inform it within 72 hours.
Huh.
My lord, that is the condition.
So fundamental allegation is unauthorized
Stop.
stock in a different and in different godowns which is not incorporated in the license. So your whole argument is even if any action is required to be taken, that is to be taken by the authority under the control order. That is the supply deputy commissioner or his subordinate under the civil supplies order and Essential Commodities Act. Here offences are not registered under Essential Commodities Act. This is under section 4 section.
No, if violation of the trade articles order is not some.
No, no, FIR is registered under.
Under section 120B 420 IPC, read with section 7 of the Essential Commodities Act.
What the section SS7 says,
Seven, in violation of the trade articles order.
violation of this order. So who ultimately it has been decided that what this is your argument. Ultimately, it has been the authorities themselves are satisfied that there is no violation, and we have been informed.
And he
So-
is the head of the authority, my lord.
He's the head of the
Head of the
authority.
authority.
So
He said-
therefore, if that goes, other sections, 120
120
and
420.
420, where from 420 comes, my
420
lord?
will not
Who
come
have
then.
cheated, my lord?
Yes, what is it say, Bhattakur?
My lord, otherwise, yes, my lord, from the FIR. I
Deputy
have gone,
FIR and
uh,
deputy,
so
these
these
are
things, only one thing I have, my lord, gone through while going through the, my lord, FIR, that, my lord, inspection was done on 31/2014.
Hmm.
And regarding that intimation, which was intimation was provided on 15/5/2013. Yes, what I have found in the.
No, what is the date of incident? Date of
31.
seizure,
31/14.
31/2014.
Date of FIR?
Date of FIR, my lord, Azahar on,
That is later on, my lord.
No, first it was seized and search and seizure,
31.
31/2014.
31, 30,
301/2014, my lord.
301, 2014. Now FIR was lodged on
That was, my lord, after. I'm continuing.
FIR is placed
My lord, yes. What my lord was saying, my lord.
on FIR is lodged on 7/3/2014.
2014.
7/3/14. And Deputy Commissioner's order was
Later on.
that what is
Yes, it is 21 June 2014.
21,
6 2014.
6/2000. And which date, Bhattakur, you are mentioning?
My lord, my lord, in the FIR itself, it is mentioned that after, my lord, search and seizure, my lord, later on 15/5/2013 intimation was given to the authority regarding that, naming the
15/1/2013.
15/5/2013
Intimation
intimation
to the 13.
to the
But the
authority.
Deputy Commissioner's order says otherwise, that they have been intimation. That is the allegation. So
Mhm.
two allegations, prima facie, the authority is the Deputy Commissioner. What is his capacity? That he has,
Inspector.
One thing, my lord, tomorrow I cannot, at 2 p.m. also I can take instruction from BIO.
Ah.
What happened to that case, my lord, regarding BIO PS case number?
it is there is stay, I think. No.
Oh, stay.
there is stay.
Then, well, considering the order of the
Yes.
deputy
Heard
commissioner.
Mr. G.N. Sayola, learned counsel for the petition, senior counsel for the petitioner, assisted by Sayola, and Mr. Bhattakur, learned additional public prosecutor. The present petition under section 482. Is it 482?
Yes.
No, 482 CRPC. Is filed by the petitioner company assailing for commencement of an FIR being registered as BIEO case number 2 of 2013 dated 2 of 2014 dated 7/3/2014 registered under section 120 within bracket B/420 of the IPC read with section 7 of the Essential Commodities Act 1955. The fundamental allegation as discernible from the FIR is to the effect that FIR page
29, my lord.
page is 29, na?
And it's a 5.
To the effect that on the basis of a tip-off, the BIEO had conducted an inquiry at the premises of the petitioner company at T.R. Fukan Road, Fancy Bazar on 29th and 13th of January 2014. And it was observed that the wholesaler, that the petitioner possessed a trade license. And as per the license, the storage godowns are allowed to utilize by the dealer at four locations described in the FIR. But it was found during enquiry that the dealer had utilized four more locations as godowns to store state trade articles, which were also detailed in the FIR. According to the FIR, the godown at serial number 4 and 5 are not authorized godown to store trade articles. And though applications for allowing such godown was filed, no, not authorized godown, okay. And therefore, after conducting the enquiry, the BIO therefore presumed that the dealer is involved with malpractice of trade articles with citing the licensing authority for hoarding of trade articles and realization of exorbitant price. Full stop. Certain examples were cited in the FIR, alleging that the dealer have to display the list of prices and stocks of trade articles in terms of clause 15 of Assam trade articles within bracket licensing and control bracket close order 1982. Dealer is to disclose the price and stocks of trade articles in terms of so and so column article, whereas the dealer had displayed the stock only, and therefore it was presumed that dealer used to realize prices of edible oils as per their will and to accommodate themselves to realize exorbitant price of trade articles by not disclosing the price of trade article in the said periodical returns as well as in price and stock display board, violating provision of clause 15 of the 8 of the order 1982. On the basis of such FIR, BIO PS case number so was registered under section 120 within bracket B/420 IPC read with section 7 of the Essential Commodities Act. Certain materials has also been seized by the BIO authorities. It is on record and it is brought on record by the BIEO authority by filing an affidavit in opposition in this proceeding. The order dated page 20, page 28. Order dated 21st of June 2014, passed by the Deputy Commissioner, Kamrup Metropolitan District. Deputy Commissioner and Collector of Kamrup Metropolitan District, whereby the application filed by the present petitioner for release of the commodities so seized, commodity so seized, full stop. A perusal of the aforesaid order. In the aforesaid order, the district collector, who is the authorized authority under the Essential Commodities Act to release such good and to take action against against the petitioner under the Essential Commodities Act, concluded the following. It is important to conclude the following. Okay. Page 28, 1, 2, 1, 2, 3, 4, and 5. Okay. 1, 2, 4, 5. 4 and 5. The collector further concluded that there was nothing mala fide behind the temporary storage of seized stock of vegetable oils in the godown of Assam State Warehousing Corporation made by the applicant company, and there seems to be substantial compliance of terms and conditions of wholesale license granted and issued to them under provision of Assam Trade Articles within bracket licensing and order control within bracket licensing and control bracket close order 1982 in 1982. Full stop. Such, it is next paragraph. It is important to note that such document is not being disputed by the prosecuting authority. Rather, it is a part of the document which is being brought on record by the prosecuting agency, that is BIEO. Thus, from the aforesaid, it is clear that when the allegation of violation of control order 1982 is recorded to be not violated by a competent authority, and such document that's order is not being disputed by the prosecuting authority. In the considered opinion of this court, no case under Section 7 of the Essential Commodities is made out, inasmuch as Section 7 of the Essential Commodities Act deals with violations of control orders. That being so, and if the materials available on record, more particularly the allegation level in the FIR, as well as the order passed by the deputy commissioner, are accepted at its face value, this court finds no material under either under section 120 CR IPC and section
120B
120B IPC
and 420.
and 420. 120B and 420 IPC. In view of the aforesaid, in the considered opinion of this court, this is a fit case where this court should exercise its inherent power under section 482 CRPC by quashing the impugn prosecution launched on the basis of BIOPS case number so ordered accordingly. Criminal petition stands disposed. Yes, what is this?
My lord, I would like to inform the court that my senior counsel Kamar is currently on legs in court number 1. May this item be taken up a few minutes later. Thank you, my lord.
Yes.
Worship.
Hmm.
Madam, item number 3, 4, 5, and 6, my lord. Out of these 3, 4 filed by the
petitioner
Hmm.
against the FIR filed by item number 5 and 6.
Hmm.
Connected case.
Hmm.
The one case is still yet to come in the list, my lord. That apart,
Which case is come to against list?
another one, my lord, that is
664, my lord.
Who filed here? Item number, please tell us, item number
3.
3.
That is filed by me, my lord.
No, item number 3, 4 are accused in FIR filed by the client, his client.
Yes, my lord.
And item number 5 is accused in FIR filed by you. And who else remains?
One, my lord, that, no, the record has not come, but.
No,
parties are
record.
on
He
the-
says that there is another case. Which case?
Yes, my lord, 664.
664
664 filed by whom?
filed by him. against
So
me.
there are 3 accused, 2 accused in your FIR.
Yes, my lord.
No, 3 accused. That is Amar Chand Maheshwari,
Ram Avatar.
Ram Avatar and Monish. That has been in his FIR. Dear Ram Avatar and Amar Chand has come and what about the other accused?
The other accused has not come. my lord.
Not come.
No.
Then what are you saying?
My lord, connected case, my lord. I'm just saying.
Okay,
that-
connected case.
Connected case.
This
is a
is by you or him?
This is by him. Last
By
time.
you,
Yes,
against you, your
yes,
FIR.
yes, my lord.
What we understand is there are two FIRs, one by you and one by him. In his case, he says that yes, I owe money. I owe money, but you have taken from my goodan this much of golds and what not.
Exactly.
This is your case. He has written to the Prime Minister, from the President to the leader of opposition to the.
Acted upon, then only. I did.
Anyway, yes, then
But
it
my-
was acted upon. Now, you lost the affair that he has taken money and
I
the
filed the CR case.
share case.
Yes, my lord.
Now, one petition challenging similar things remains. What is the number?
That is 616, my lord.
Monday,
No, 664, my lord.
664.
Not 661.
664 Monday.
616
There is
has
no
come.
talk of compromise between you.
But another fact is, my lord, it is about 10 years.
Ah.
The client, so what today morning I
Hmm.
contacted the client. They have not been served any notice from the either by the trial or from the police, whether any charge sheet has been filed or any,
I think there is a stay.
but order does not show. it.
No stay.
No.
You have the obtained the instruction. The learned counsel for the petitioner in criminal petition number 616 and the learned counsel for the petitioners and the respondents in criminal petition number 616/2014 submits that another criminal petition being 664 of 2014 is also pending adjudication, and the same arises out of the connected affair. Therefore, they press to list this matter along with the aforesaid petition. Full stop. The learned additional public prosecutor submits that he may be granted some time to complete his instruction as regards the status of the prosecution after lodging of the affair, inasmuch as there was no interim order passed by this court. Full stop. In the totality of the matter, the prayer stands allowed. List this matter on Tuesday, next Tuesday, in the order columns, along with the criminal petition number so and so, full stop. On the said date, the learned additional public prosecutor said complete his instruction, full stop. But be ready, even if it is in order, we may proceed. Okay? 12? 12 is there. Okay. You have the instruction. Motion. Please make cause list. Civil relevance.
May I please your lord,
Yes.
this is an application 482 CRPC
Hmm?
for
For what?
further investigation of the case, my lord.
What further investigation?
Madam,
Order has been rightly been passed.
No, my lord, we filed an appeal, revision to the district judge also. Then it has turned down. CGM also not, has turned down. And then we have come.
They said they don't have power.
No,
rightly, that-
But
that-
173(8), there is a power. There is a judgment of the apex court in this respect.
But there is no material to,
My lord, give me some time, my lord.
yes.
This is an FIR lodged by the SDGM Kachar.
Huh.
That was on, my lord, before I take your lordship, page, annexure 1, page 15.
Page,
I'm reading the FIR, my lord.
Page
I'd like to
15.
inform you that this morning.
page
about
15, just wait a minute, don't go so fast. Page
2:30.
15.
This morning, I would like to inform you that this morning at about 2:30 CM,
Hmm.
some 2 or 3 person breaking open glass panel of the ventilator, unlocked the hook of the drawing room and entering my house, showing a knife to my wife and threat of dire consequences to both my wife and minor son, took away the following article: cash 30,000, gold ornaments weighing about 22 tolas, diamond ring 1 piece, diamond nose 1 pin. Then, my lord, police have charge sheeted the case, page 16,
Page,
16.
Hmm.
There is annexure 2.
Hmm.
Under section 380, 457, 307 IPC.
Hmm.
Then,
who
my
are
lord,
these accused?
beg your pardon? There are 11 accused.
Okay,
Uh,
now who are you?
I'm the informant.
Okay, then,
Then I take your lordship, annexure 3. The petitioner, the informant, he made an application,
annexure,
annexure, my lord, it is annexure 3,
Page?
page 22, relevant portion, before the CGM,
yes,
where he has mentioned, my lord, I take your relevant portion, my lord.
Hmm.
The, on the event of the housebreaking at night, committing theft, armed with sharp weapon, with threat of to dire consequences by the accused inside the official quarter of the informant on 3/5/2011, while serving as SDGM Sadar, Kachar Silchar. A written ejaar has been lodged with then OC Silchar PS, and on the basis of said ejaar, the OC of
no,
the
no,
state.
your grievance is search sheet is filed, according to you, what should be?
Investigation was not done, main accused have been left out.
Who is main accused according to you?
It is namely, my lord, page 23, you lordship will get,
Hmm.
para 2.
Huh.
In spite of that no steps had been taken to getting recorded the confidential statement of the said accused, nor the accused Bimal Pal and Montosh Pal.
Who has named this person as accused? In the FIR, there is no name.
No, but he said, he is in.
No, where is his statement? Where is his 161 statement?
The informant said that no TIP was done.
No,
At
no,
that-
where is his statement before in 161? Let us go one by one.
It is not
You
there.
cannot suddenly come and say that, no, he has, so and so are accused, I am not the accused, everything is over.
Let me read out.
No,
his
just I want to
previous-
understand.
Yes.
Of course, you are the person who identified this
Yes.
person as the thief, but you have not named in the FIR them.
How can I know their name?
No, you don't know,
Suppose-
but subsequently know. How do you know that name? That is my question. So
I
I think there must be 161, there must be statement. Because IO has not arrayed him as an accused. A person is not, anybody appears for that person?
No, these respondents are not coming.
Okay. So assuming, we'll hear you. No problem on that. Just a query came into my mind.
Yes, sure.
You file an application in a fine morning, everybody can come and say the investigation is bad, he is the accused. But neither you as an informant made an app in his name in the FIR. There is nothing in 161 statement. So there must be somewhere that he is the accused, but he has not even considered IO. Where is that?
that-
Anything, any record, anything has come? Okay, yes, proceed. Okay.
Bimal Pal and Montosh Pal
Mm.
had been arrested. Rather, they are surprisingly, the Bimal Pal and Montosh Pal are not charge sheeted.
Mm.
They were arrested but not charge sheeted.
Okay.
And one of the brother of the Montosh Pal, namely Manoj Pal,
Mm.
had been made witness in this case. As such, it is an apparent that the brother of the accused Montosh Pal, who is made a witness in the case, who is a brother of the accused Montosh Pal, and on that count, fairness is evidently lacking. Then I take your lordship to para 4.
Mm.
That evening after a long time, date of commission of the offence,
Hmm.
one of the prime accused of the case is namely Deep Nunia, had not been arrested.
That is why we have to understand that you are saying all these as prime accused. They are not named in the affair. From where are you saying all this?
Let me go through you will get it. Let
Is
me
it
go-
not? Or am
Yes,
am
we
I
are
am I
thinking
asking some
rightly-
irrelevant question?
Yes.
Am I asking some irrelevant
No, no,
question?
rightly raised the question. Well, how
If
he
I am
got-
asking you, tell
what
us.
from the names has come up to him.
Ah,
However, lastly, the belated stage of the investigation, the IC Ghungur
Hmm.
outpost arrested the said accused at one night
Hmm.
without any coordination and knowledge of the IO, although it is an undisputed fact in the instant case that the accused committed the theft on the fateful night by wearing mask and armed with sharp weapon, but surprisingly enough, no attempt had been taken up for TIP. Then, my lord, Para 5,
statements
that during the course of the investigation, IO had recorded the statement of the witness under 161 CRPC, but the statement available on record are totally deviating from the statement given to the IO at the time of investigation.
How do you know that?
Probably he has compared it. He was a magistrate at SDGM at that time. The IO of the case under the influence of the accused had prepared the statement under 161 CRPC, which are available on record in such a manner which are more favorable to the accused rather than supporting the prosecution case. Then 6, my lord, that the case in hand, although relating to the offense against the property and the offense affecting the human body, but surprisingly enough, no sincere effort had been made to recover the single piece of the stolen properties, and as such, said conduct itself bears huge doubts and uncredit worthiness on the method of the procedure adopted for the investigation of the case. Number 8, under the above fact and circumstances, the instant case deserves to be reinvestigated by a competent and independent investigating agency for the interest of the fair and administration of the justice, failing which your humble information
So
shall.
who will pass this order of reinvestigation?
And my lord,
By who will pass?
CGM said that I have no power.
So has the power of
Your
magistrate.
lordship has got
Where is the application?
173. Yes,
Where is the decision application seeking setting aside this order?
my lord, kindly come to page 26, Annex 4. The order passed by the landed CGM. May I read, my lord? Page 26, Annex 4.
Yes. Yes.
My lordship gone through, they rejected. Then, my lord, he has filed an application to the SP, Annex 5. Again, Subarnapur Police. Here also he has asked the prayer for passing necessary order for further investigation of the case,
Hmm.
but nothing has been done. Then he has come before your lordship,
Challenging the order of the
CGM.
CGM.
Now, your lordship will find what is the grounds. The ground that, my lord, ground number 3, my lord, that the petitioner state that admitted before the landed chief judicial magistrate Kachar praying for the passing necessary order of the reinvestigation of the case by competent and independent investigating agency, passing necessary order as it was satisfied with the investigation of the case, the aforesaid petition was received and registered as petition number such and such. The aforesaid petition was taken into consideration by the landed chief judicial magistrate Kachar, and the case was listed on 5/12/13, whereby by the order number 5/12/13, the petition for reinvestigation of the case was rejected by the order number such and such, Annex 4. That the petitioner state that he has also submitted a petition before the Subarnapur Police Kachar Silchar praying for passing necessary order for further investigation or the reinvestigation of the case.
Mr. Vishwas,
Yes.
that we can also read. That is not an
Yes.
issue.
Now, my
What is your legal point?
legal point I am coming. There is one judgment of Apex Court, my lord, on this
Hmm.
point. kindly.
What that judgment says?
Saying that the High Court has got the jurisdiction.
No, High Court has got the jurisdiction in exercise of what power of? High Court is having many power. In some cases, it's a first appellate court under section 90 of CPC. Sometimes it is High Court is can grant bail under 439, exercise jurisdiction under
Yes.
439, 438. Sometimes it's exercise power under Article 226. Now, what is that power?
Your
Yeah.
power, 482 only.
482. And what is your prayer? Your whole
My-
case
my
is that
prayer
set aside this order is bad, and ask the magistrate to direct the investigation. This is
The
your prayer.
investigation of the case.
By the magistrate.
Yes. That is my prayer.
And the order is very nicely written that this power is not vested with this.
Planet CGM is absolutely right.
If Planet CGM
One
is
part.
absolutely right,
He has
it
no
is mixing
power.
of
He has
it.
no
And
power.
this is not,
173 cannot be.
will not exercise a power under 482 in this case.
Your
More
lordship-
particularly when a reason order is written and it is a case of 2013 at this stage.
But that is
nothing-
a, yes, that your lordship can view, that the matter relates to 2013.
No,
Now,
that is
probably
not.
that case has been already proceeded because
that-
there was no stay order. The case
Nothing
might
is
have been
there.
proceeded. I do not know what is the fate of this case now, after the 10 years. But I pray for the judgment which I placed of the apex court. I have indicated the para also.
Yes, you have indicated the para, but at the same time, the learned CGM has nicely dealt with all these judgments, that why he cannot pass an order, isn't that it?
That's why he has no power. That's true. But your lordship has got the power. Your lordship invoke or not, that is a different thing. But power is there. When there is a reasoning, if your lordship find that learned CGM has not committed any wrong, then your lordship is also correct. I have got no grievance for that.
Dismissed, order to follow.
Diplomat.
Yeah, please, Your Lord.
Hmm.
Petition under section 482 for passing of a criminal proceeding on the basis of a settlement arrived by the parties outside the court. Lordship.
Mm.
Allegation was under 366 of kidnapping. Thereafter.
Rape,
Kidnapping.
kidnapping.
Yes. Thereafter,
Then,
charge sheet was filed
Hmm.
and thereafter someone were issued by
who has compromised this case?
the informant, the father of the victim.
How can informant father compromise on the basis of a victim? On representing the victim? Why should we not prosecute this father, informant, asked to prosecute him?
He's the informant of the case, Lordship.
So what? It's a offense against the person or victim, kidnapping of the victim. Maybe.
Yes, Lordship. Yes.
What is the present status?
Stayed.
Paid.
My lord, it was stayed on 7/11/2014, my lord. As per order of the honorable court.
Satisfy us that father, it is he was a minor or major? He was major or minor at that point of time? Yes. Saurabhati,
I have an affidavit at page 15.
that we have seen. She was minor or major at that point of
Because
time when
that,
she
of
was
course,
kidnapped?
From the FIR, there is nothing discernible.
Hmm.
From this affidavit, also nothing discernible.
Understandable.
So what my prayer obviously would be to this query of your lordship would be that I have to take instruction, but I don't know whether I can take instruction or not. Because 2013 and now we are in 2020. The fact remains, my lord, that yes, this query is a very
Is
valid
it
query that
permissible?
is it permissible. Whether a father can
And
compromise
that
on
way
this.
offense like kidnapping and all.
My lord.
Specific, yes.
Perhaps she is major at that point because she's 66. If
So if she is a measure,
perhaps
she is
not
the
this-
victim. And you have not made her a party also, that she has also consented, what not.
Father was made party as a informant.
Mhm. Now the end argument will be, I don't have any connection with my client. Isn't it?
No, no,
You have.
yes.
How you then? Place this matter Wednesday on the prayer of the learned counsel for the petitioner. On the said that he will address this court whether the father can compromise a non-compoundable offense committed upon his daughter.
Obliged.
What is this?
My lord, this is for a quashing, my lord, one
Hmm.
proceeding of under provisions of section 12 of the DB Act, my lord.
Who are you?
I am the
Husband.
respondent, my lord.
Husband.
So called, my lord, this is the alleged husband, my lord.
So you say that I am not husband, so I will not give. So that is you decide very inappropriate cases. That's
No,
all.
actually not that case, my lord. The, she.
So why two petition, criminal 311 and 974?
Next one, 125.
125. What are your grounds?
Here, my lord, what happened, my lord, this case,
Hmm.
according to this case, my lord,
Hmm.
they said, my lord, in the petition, my lord, that paragraph 6, that
Hmm.
she was tortured by the husband.
Hmm.
And my lord, therefore, my lord, he got to the hospital
Hmm.
and only quality, my lord.
Hmm.
Allegation is only quality, my lord.
Hmm.
This petition has been filed
Hmm.
on 16 July 2014.
Hmm.
Prior to that, my lord, same cause of action, same subject matter, immediately when the incident has taken place, my lord, in the
Hmm.
year of 2009,
Hmm.
they have lodged an FIR, my lord.
Hmm.
The case has been registered under section 498A.
Hmm.
And my lord, this case has been decided in favor of me, my lord.
You decided in favor of 498. That is
So-
fine. And what is the finding?
And then, my lord, after deciding this case, my lord, after
Mm.
that judgment, my lord, this petition has been filed, my lord.
Mm.
It's the same cause of action, my lord. Lordship will find annexure 1, the petition
Mm.
under section 12.
What was the allegation there?
Allegation.
But DV order is for what? Any order has been
Mm.
passed, DV?
Only section 12 of the DB they have passed, only query has been raised, my lord. That is at page 6.
Where is her complaint? Okay, 498 maybe you are acquitted. Now, what is your grievance before the DV court?
DB code is page 13.
Yes,
13. This is
1-3.
1T. That is at annexure 1.
Huh.
Paragraph 6, my lord.
Paragraph
6.
page 12. Page 13.
13.
Rupanjali.
I am reading, lordship. That on 27/9/2000, while the petitioner's brother, Sri Nandeswar Barua, and his wife went to the residence of the petitioner respondent, they found the petitioner is senseless condition, and for which they informed the matter Bhugdoi OP and
So prayer is for separate residence. Isn't it? And medical, some payment. Regular medical treatment, cost of business, whose body is suffering from severe body pain for ritual tortures. Okay, now.
my lord, what happened, my lord? With the same allegation, my lord,
Hmm.
they filed this, my lord. While that
No, same allegation is 498A. is not it?
Yes,
So suppose 498A, you are acquitted.
acquitted.
Will that mean that husband and wife relation is gone? Will that mean? Is it any findings in the 498A court that they are not husband and wife? Huh?
That has not been decided. my lord.
So therefore, there is nothing declared or nothing is there as on date that you are not husband, you people are not husband and wife.
The such petition is pending, ma'am.
No petition is pending. So
From
therefore,
from
she
my
files
name,
an,
my
app-
lord, by
she,
her name, ma'am.
no, she files an application saying that please give me a separate residence. Now, whether she is entitled for separate residence or not, a procedure is followed. That let the procedure be followed. You take your all defense before that thing. You have filed written statement. There also.
No, no, yes, my lord.
Yes, you have filed that. Then what happened?
Written statement and then, my lord, we come to this court, my lord.
So let the magistrate decide what is required. And what is the other case?
This is 125, my lord.
What happened there?
What that case is another case, my lord. What happened, my lord?
Hmm.
First, my lord, they have filed an application under section 125, my lord.
So in this case, your whole ground is that since
I
498,
can understand, my lord.
so 498 is
Cruelty, my lord, that cruelty part is over, my lord. That-
cruelty part may be over, but do you propose to say that only that cruelty as alleged in the 498A, parameters under 498A
Yes.
in a criminal proceeding and anything under DB Act are exactly same, and if one is acquitted and there is no order can be passed in DV, are you proposing to say that?
No, no, I am.
If not that, you contest it there. This is one. Second is what is 125?
125 is that, my lord. What happened, my lord? First, they have filed a case, my lord.
Mm.
We have contest, my lord.
Mm.
Case has been decided.
Mm.
Case has been decided in favor of her, my lord.
Mm.
And my lord, that case has been decided without considering the DWs, my lord. We approached the High Court. High Court has passed an order
Mm.
that you have to decide the entire
Okay.
case again.
Okay.
And my lord, re-decided.
Okay, then.
Re-decided and then dismissed, my lord.
Mm.
They have filed a revision before the session court.
Mm.
Session court has passed an order.
Mm.
And this, at that point of time, my lord, they have filed two applications, my lord.
Mm.
One application before this honorable court, one application before this session court.
Mm.
The session court has passed an order, then they have withdrawn this case, my lord.
Mm.
At the time of the session court order, my lord, at the time of
So according to you, there are two proceeding
was parallelly
was parallelly pending
before two different
challenging one same order. Same order.
Same.
Now they made a submission before the session judge that High Court's
This has been withdrawn.
withdrawn. Now session judge
After getting the order,
after getting which order?
session court order. And my lord, I have challenged the merit also, my lord.
Okay, let us first come to this case. What is your ground? Let us see. 125 will go. So your whole case is since 498A, I have been acquitted. So there cannot be any proceeding under 12
On the basis of the cruelty, my lord.
on the basis of cruelty.
Okay, para 6 is that, my lord,
Para?
of their application. Page
Mm.
2013, my lord.
Para 6. Okay, let us read what para 6. So the incident took place when 27/9/2009.
9, my lord. And this application has been filed in the year of 2014, my lord. Long back, my lord. While this that 498 has been decided in favor of me, my lord, they have taken this plea, my lord.
What do you, how, what do you, that is what is paragraph 7? Please read it.
paragraph.
7. At page, internal page 2 of your, of that petition, Mr. Bora, what is this?
That the Honorable Supreme Court stated that the Mohammed Ahmed Khan versus Begum so and so. Lordship, nine.
Determined that the
Nine.
petitioner was the married wife of the
DV.
respected the
DV2.
maintenance to the petitioner, but the his contracts.
এইটো নেকি?
According to you, she is your maid. Huh? According to you, she is your maid.
Yes, ma'am.
Okay. So therefore, you are not entitled.
Yes,
She is not entitled.
ma'am. What happened, my lord?
Hmm.
There was some position.
That is the difficulty. Actually, what happened is to be decided by somebody else, not by this court.
Actually, my lord, PW.
Until and unless you show an admitted position.
My lord, actually, what happened, my lord? Actually, sorry. My lord, PW who adduced their deposition, my lord, before the court, my lord. They have said, my lord, they were present in the ceremony, but there is no any persons from the petitioner side. How they can perform the marriage, my lord, without in absence of the groom, my lord.
No, that is not the issue.
Groom, my lord.
On these proceedings, the either in 125 or this DV Act, court cannot go deep into whether marriage is legal marriage, they were married or not. This is not the subject matter of proceeding under 125 for this. If she has claimed to be your wife and there is a direction, you ought to have gone somewhere else. And what is your written statement?
In which case, lordship?
At page 16.
No, which item, which one, lordship?
That is the item we are taking.
974.
974. Everything is in mess.
Lordship, kindly, no, I am appearing as an amicus in this case.
Hmm.
Lordship, kindly see the paragraph. The whole case is that he was acquitted in 498. Lordship, kindly see the paragraph 30, page 33, man.
Page 33.
That finding is not being challenged.
Hmm.
Though he has got the acquittal by the finding of the
That
trial
is
court.
what I am saying.
Lordship, kindly sir, last few lines. 1, 2, 3, 4, 5, 6. From the bottom.
Paragraph 33.
Paragraph 30, my lord, page 33.
Okay.
Last 6 line, my lord.
Uh,
From the bottom, though
mm.
though the defense through the DWs attempted to establish the fact that the informant was brought as a part-time maidservant to the work day to time to look after the children of the accused person, but the prosecution evidence are sufficient to establish the fact that the PW and the informant has been living in his house after socially
That
married.
is what I was asking.
Thus, under the context available evidence, I am of the opinion that the prosecution has been able to recharge the burden under section 103 of the Evidence Act, and also able to prove the fact that the marriage between the informant and the accused beyond all reasonable doubt and required to be observed. Honorable Supreme Court passing Sandeep sir.
Are you paying anything? This has been stayed.
Okay.
This DV, my lord.
Huh?
In both the cases, the stand is same.
Stand is same.
Stand is same. The
Yesterday we passed a judgment saying that these cases cannot be
and
taken.
the strict compliance of the proof of the compliance.
Not is
not
not necessary. We
necessary.
have already dismissed
And
almost
the-
3-4 matters. All are decided ground is raised, I think, by the lawyer, saying that you say I am not your wife.
And the section 50 of the Evidence Act
Evidence
is
Act.
very clear, man.
Very clear.
No, no, my lord. Coming to that, the 125 is just a slight.
No,
different.
125 will come
Yes,
later on, but what about this? Now that this matter is pending since 2014, and sorry to say, this is not a case to pass the motion stage itself. As on date. Forget about 10 years pending. It is a fit case to be dismissed in the motion with cost. Now,
In DV, my lord, nothing is adverse till now.
nothing is adverse.
Right.
Let
Let
him
him
take,
face-
he is free to take any defense, any defense. Heard Mr. Purva, learned counsel for the Bura, learned counsel for the petitioner. Also heard Mr. A.M. Bara, senior, learned senior counsel, who has appeared as an legal aid or what you call
Amicus.
amicus, who has appeared as an amicus on being appointed by this court and assisted by Mr. B.A. Chaudhuri. The present petition under section 482 CRPC is filed assailing and proceeding for quashment of a proceeding registered as miscase number.
Already she got the second marriage with spotting.
Oh, I do not know. You go and have all this. We are not
Yes,
going.
Yes,
You
yes.
go and say them. What uploaded to procedure? Equal. Proceeding registered as miscase number 775/2014 under section 12 of the Protection of Women from Domestic Violence Act 2005 and presently pending before the learned Chief Judicial Magistrate Jorhat. The Chief Magistrate Jorhat. The fundamental ground of challenge is that the respondent wife, on the basis of the same incidents, lodged an FIR on what is that FIR? On 2/10/2009 before the officer is in charge Bogdoi Police Station, alleging cruelty and assault, which was registered as Jorhat PS case number 481/09 under section 498A IPC. Subsequently, the present petitioner was surseated, and after a full-length trial, the petitioner was acquitted. Full stop. In the aforesaid backdrop, the learned thereafter, full stop, thereafter, the application under section 12 was filed by the respondent wife. The ground of the fundamental ground of challenge is that as the petitioner has already been acquitted under 498A IPC, there cannot be any reason for the learned court to proceed with the DV proceeding under the DV Act, in as much as the same is based on the same similar incident, and it is an abuse of the process of this court. Full stop. Mr. Bora, learned amicus, referring to the order of acquittal passed in order of acquittal of the petitioner under section 498A IPC, submits that though the petitioner has been acquitted for the commission of offence under section 498A, however, the learned trial court has categorically concluded that the petitioner and respondent the petitioner could not establish that petitioner and the respondent are not legally married. Full stop. And therefore there is no bar in proceeding under section 12 of the DV Act, in as much as these two are distinct and separate course of action. I have considered the arguments advanced by the learned counsel for the parties. First up, it is correct that the petitioner has been acquitted by the learned Chief Judicial Magistrate Jorhat in GR case number thing is written. GR case number 995/2009 from the charges under section 498A8 IPC. However, first of all, it is also on record that the petitioner has taken a specific stand that the respondent is not his legally married wife. Rather, she was a maid servant who used to serve his children. First of all, however, such defense was totally such defense taken by the present petitioner was rejected by the learned trial court below, which has admittedly remained unassailed. Full stop. The relevant portion is quoted of the aforesaid judgment is quoted here in below. Green page to green page 33 to 34. Okay. Full stop. In view of the, I have also perused the application filed under section 12 of the DV Act, as well as it is on record that the petitioner had entered appearance before the aforesaid appearance in the aforesaid proceeding and also filed a written statement in the meantime. Full stop. After perusal of the aforesaid material, this court do not find that this is a case where this court should exercise its power under section 482 CRPC, inasmuch as this court has not found any malice in filing such application, or that a bare reading of that application does not make out any case for grant of any relief under section 12 of the DV Act. In view of the aforesaid, the present petition stands dismissed. Interim order passed earlier stands vacated. While parting with the record, this court places on record the assistance given by Mr. A.M. Bora, learned senior counsel as amicus. And next, LCRB returned back. Yes, what is next? Tell us.
This case is for claiming maintenance.
Where is that order? Maintenance order? Impugn order, page?
Page 86 to 91.
86 to 91.
Well, in this case, they have preferred a revision against the order of the system judge, my lord.
Okay.
Initially, she filed a case, my lord, which
Hmm.
was allowed in her favor.
Hmm.
They have challenged it, my lord, before the High Court.
Hmm.
Then the High Court remanded back to take the fresh evidence,
Hmm.
and the DW was presented. Then this time, my lord, learned trial court gave a judgment in the favor of the petitioner, my lord.
Hmm.
Then that was challenged before the session judge, my lord, by this lady. my lord.
By you.
Yes, my lord. Then the session judge
Reverse.
reversed the finding, my lord, and remanded back
Hmm.
for deciding the quantum. Nothing has been decided, my lord. Only remanded back to decide the quantum to the Chief Judicial Magistrate afresh. So
Okay.
there is no question of granting, only that is pending, and they have challenged them.
So according to them, since it was decision is reversed, that's why they have challenged.
Yeah.
Where is the order?
Operative person also
Page.
page, my lord, page 90, my lord. The stand was same, my lord, husband and wife, my lord. So that he is not the husband. Planet Revisional Court, my lord,
Hmm.
decided that on the basis of the evidence, my lord,
That is page 86.
page 90, my lord.
Page 90.
It starts from 86.
Hmm.
90 is the operative paragraph 12. The basic principle of law, the burden of proving the particular facts on the person alleges the same, then the brought receipt and the person denies the particular fact. All the independent PW sufficiently prove the fact that the petitioner is the wife of the OP
Hmm.
and she left the matrimonial home due to continuous physical torture on her OP. On the other hand, OP has denied the claim of the petitioner and the proof of the fact the petitioner stayed in the house of OP as a maid, failed to adduce as a cogent
You are
evidence.
reading page, paragraph 12, isn't it?
Yes, my lord.
Yes.
All the deponent, my independent PWs.
Mm.
Seventh line, my lord.
Mm.
All the independent PWs sufficiently prove the fact the petitioner is the wife of the OP, and she has left her matrimonial home due to continuous physical torture on her by the OP. On the other hand, OP is denied the claim of the petitioner. In the proof of the fact, petitioner stayed in the house of the OP as a maid, failed to adduce as the cogent evidence. All the independent DWs deposed they have seen the petitioner in the house of OP and heard from the OP that she is engaged as a maid in the house. But it appears that none of the aforesaid witnesses deposed that they have seen the petitioner to work as a maid in the house of OP.
So everything is done. Why not quantum is decided?
So,
Is it not is it powerless to decide the quantum in revision? Yes, that is your ground.
Yes, my lord. Now, my lord,
Hmm.
here both says, my lord, everybody has said that
Hmm.
she is the wife,
Okay.
individual.
Hmm.
My lord, individual witnesses are PWD.
Tell us any perversity in this finding.
Yes, my
That
lord.
your DW said that
DW says nothing, my lord. I have annexed all the DWs.
Ah.
Nobody says there is a marriage was ceremony, marriage
no,
ceremony.
forget,
was
but it is
solemn,
your case.
And
You will have to
and-
say,
and
DWs will
PW,
have
my
to
lord,
say that
PW
married.
No, PW also say
What, where is that?
that PWs, my lord, in the record, my lord. PW3, these are the individual, my lord. PW4, PW5.
No, okay, forget about that. Forget about that. Can we decide whether you are husband and wife or not? This is your whole defense.
My lord,
Can
I
it
am
be?
not husband, my lord.
No, please don't argue that. If I'm not husband, why should I pay? If we're husband or not is a dispute. Can that be decided for the purpose of 125? That is that you enter, tell us. You go to a competent court and seek a declaration. In fact, in a 498A, where it is required, that has been appellate, you have failed to prove.
My lord, she claimed the maintenance from me as a wife.
As a wife.
She is not my wife. I am saying that she is not my wife.
Hmm.
And her witness says
Hmm.
we are not confirmed whether the marriage was solemnized or not.
Hmm.
Her witness, individual witness, my lord.
Hmm.
These PWs are there, my lord.
Hmm.
With depositions are there, my lord.
Suppose marriage is not solemnized. You are
They are not
husband.
living together, my lord.
If you are staying together, that matter ends there.
They are not
125.
living together, my lord.
125 is law is different.
And my lord, now
Hmm.
she got married to another person, my lord.
Where is
Now
that?
that is my
You
lord.
you file an application under 127.
Yes,
Matter ends there. Section 127 CRPC.
matter ends there.
Matter ends there.
Subsequent development.
Subsequent development come and say that yes, this, no, I'm not entitled to anything. In fact, when quantum is decided, then also you can say that there is no current.
Yes. 120.
We'll observe that.
That is
Why will
sufficient.
not see Mary from
Then strict proof of
2004?
marriage 125 is not necessary.
Not necessary. Not at all necessary. We have almost dismissed yesterday, day before yesterday, around 8 matters. Even we are not dictating a petition. That is already there yesterday, day before yesterday. That is not required. That is the judgment I'm just looking into.
And section 50 of the Evidence Act is very clear.
Very,
my lord.
very clear.
The opinion, my lord.
Ah.
The opinion is sufficient.
Yeah.
No, no. Actually, what happened, my lord?
What we cannot help it. This is the law.
On
You are
127
saying,
27 of the petition delay hold that, right?
oh,
Same
127, you file an
circumstance, she is
application.
already married, shows that she's not
No,
entitled.
not
That
entitled.
is sufficient.
We'll say.
Yes, sir.
You have taken dictation na earlier order. Now it will be 125.
Get one of the co-parties
Uh,
is
in
already married,
by
so
application
it's
under
not
section
entitled.
12, 12.
ইমান কিয় কৈ থাকিব লাগে? 2 ছেকেণ্ডত শেষ হ'ল তাত। বিয়া হৈছে তাৰে প্ৰমাণ এটা দি দিলে হৈছে।
397, ready section 482 of the Criminal Procedure Code 1973. Assailing an order dated 28/5/2014 passed by the learned additional judge Jorhat in criminal revision number 40/2013 filed by the respondent wife, whereby the judgment dated 11/11/2013 passed by the learned additional CJM Jorhat in miscase number 11 of 2010 was reversed and the matter was remanded back for determination of compensation under section 125 CRPC. The respondent wife filed miscase number 11/2010 before the learned additional CJM Jorhat under section 125 CRPC. Full stop. The aforesaid judgment was set aside. Aforesaid judgment. By the aforesaid judgment, the application filed by the respondent wife was dismissed. Where is the judgment? On what ground? Judgment is. Why that was judgment? Husband and wife. Or what?
That is 78 to 85.
70?
8 to 85.
78 to 85.
Page 85 is.
Okay. 85 was dismissed basically on the ground that on the ground that on the evidence of PWs, the evidence on the ground that the evidence of PWs does not inspire the confidence of the learned judge, that the petitioner and the respondent is husband and wife. Full stop. Such decision was reversed by the learned additional session judge in criminal revision number 40 of 2013 preferred by the respondent wife. The learned session judge, after elaborately dealing with the evidence of PWs as well as DWs, came to the conclusion that the independent PWs sufficiently proved the fact that the petitioner is the wife of the revision petitioner is the wife of the opposite party, and she left her matrimonial home due to continuous physical torture on her by the husband. Full stop. It was further concluded that the husband, though denied the claim of the petitioner and asserted that the petitioner was a maid, not a legally married wife, failed to adduce cogent evidence. According to the learned session judge, all the independent DWs deposed that they have seen the petitioner in the house, petitioner in the house of the opposite party husband, and heard from the said person that she is engaged as a maid in his house. However, none of the aforesaid witnesses deposed that they have seen the petitioner to work as maid in the house of the OP. It was also concluded that the independent PWs has laid direct evidence in proof of the claim of the petitioner, whereas none of the independent DWs had laid any direct evidence in proof of the claim of the OP. Full stop. Accordingly, the decision of the learned judicial magistrate was reversed. Full stop. This issue should not detain us any further, inasmuch as it is well settled that in a proceeding under section 120 CRPC, the absolute proof of marriage is not always necessary. And when a party denies the marital status, he should opt for appropriate remedy either in civil or criminal court. Therefore, in the considered opinion of this court, the learned additional session judge has not committed any illegality or irregularity to exercise, leading to exercise of power of this court under section and revisional power of this court. Therefore, this court is not inclined to interfere with the decision of the learned additional session judge impugned in the present proceeding. Accordingly, the petition stands dismissed. At this stage, the learned counsel for the petitioner submits that the respondent wife has already got married, and therefore on that count, the revision petition should be allowed. However, this court cannot go into such disputed facts inasmuch as the respondent wife is not represented by her counsel, but rather by an amicus appointed by this court. Full stop. Accordingly, while parting with the record, it is clarified that the petitioner shall be at liberty to approach the learned courts below, filing application under section 124 CRPC.
About the parallel proceeding, my lord.
Huh?
Parallel proceeding.
What parallel proceeding?
My lord, what happened, my lord, while this application was filed before the session.
Oh, 125 and DB can proceed
No, no,
parallelly.
no. Here, my lord, kindly turn to page 92. This order has been passed. This order has been passed.
Hmm.
This order has been passed on 28/10.
Page 92, yes.
This is after passing this order, my lord.
Hmm.
This order 28/5/2014. After that, my lord, this case has been withdrawn, my lord. Annexure 9.
Now, what is to be done under this order? Tell us. What is
At
the
time
if?
of the passing this order, my lord, one case is pending before your lordship, my lord.
So,
That has been withdrawn after passing this order.
so will that nullify that order? Do you want to say, will that nullify? Because no order was passed.
They have withdrawn after passing this session court order, my lord.
This
When
is,
they get the relief,
understand,
yes, yes,
according to you, two revisions were pending.
parallelly going.
Well, she is not here. You are doing CC amicus. Then
Even then, my lord,
nothing,
does not
does not,
debar
it's
her, yes.
materially affect anything.
affect.
This will not materially affect anything except her credential, which you can raise anywhere. You should have filed different applications with cogent evidences.
All right.
Interim order stands vacated. LCR be returned. By time being. Okay.
The other side counsel probably.
Yes, what is this?
Special practice CBI is on leg, logic.
CBI counsel, if one, he is only have 2 legs. And there are criminal courts 5 to 10. So his option to be on legs in which court is up to him. Yes.
My lord,
Yes.
in this case, I have come up for quashing of the charge framing order, my lord,
Where
which
is
is
that?
annexure 3,
Hmm.
page 58.
This is item number.
Yes.
What is this IA?
My lord, earlier we used to file a separate stay petition, my lord.
Okay, there is a stay.
There was a stay.
Ah.
Now because of that pronouncement of judgment from the Honorable Supreme Court, 6 months
Ah.
automatic.
Now what
execution.
happened thereafter?
Thereafter, the trial is on now.
Any evidence?
Yes.
How
Round
many
about
witnesses?
7 to 9 witnesses has been examined, my lord. That is all there, my lord, but my petition is still pending. I'd like to show your lordship.
Why
my
should
lord.
we waste our time?
No, because it's a valuable right has to
But
be
a
extinguished.
valuable right has not been protected by interim
No,
order.
it has protected, my lord. They have come up for for setting aside the stay orders, my lord, that
Hmm.
IA was filed.
Hmm.
No order to that effect has been,
No, be
But
that as
subsequent
it may,
development is
but
that, my
how total, how many witnesses?
round about 130, my lord, somewhere around. my lord.
So, do you want any observation? Suppose we dismiss your petition on merit.
That is one. aspect.
Then also already witnesses are examined. That might have some
No,
Think
witnesses
over
are
it.
examined, but till now nothing has come up. So that records scan copy may kindly be
Yes,
forwarded.
where is the CBI counsel? Who, in which court?
Three Lordship, matter is going on.
Okay,
Let
after
us
some
wait.
time. Yes, Mr. Biswas, what is this?
My lord, there are three petitioners in this case.
Hmm.
As per my instruction, petitioner number 1 expired.
Hmm.
Now, my lord, the total sentence is under 2 sections. They were found guilty under 2 sections.
Hmm.
One is 447, that is criminal trespass,
Hmm.
and other is 323, that is heart.
Hmm.
Now, my lord, the learned chief judicial magistrate under 447, 500 rupees each fine.
Hmm.
And under 323, my lord, 1000 rupees fine to all the 3 appellants.
Hmm.
In addition to that, 2 years imprisonment to petitioner number 3. When they filed an appeal, when they filed an appeal before the session judge, the session judge interfered to a limited extent. He has reduced the sentence from 2 years to 3 months. Rest intact, that 500 rupees and 1000 rupees. Now, my lord, it has been more than, my lord, 13 years, my lord, 2011 matter, my lord. So whether this 3 month can be converted into imprisonment, my lord, only to that extent, my lord. Otherwise, my lord, only because after 11 years, sending a man behind the bar for.
Give us a handle.
Huh?
Give us a handle.
My lord will kindly come to PW6. That is because I am on heart part. Heart.
PW6.
Doctor, madam.
Doctor. Cross-examination.
PW6.
Yes. Well, the handwriting is really
Good. Again.
fantastic. I had to, it is in English. Despite that, I had to ask some, my lord, expert to type it out.
Do you have any copy?
Yes, I have a type copy with me.
PW6.
PW6, that is the.
Why you take the advantage of that? Give us to also. Why are you keeping only for your?
Oh, acha. Yes.
PW?
PW6 cross part, my lord, will see when the incident took place and when he went to the doctor. And it is the doctor's own evidence. And admittedly, the incident took place on 1st of the month, and he went after 5 days. If his wrist was fractured because of that incident, he would have immediately gone. And moreover, there are 4 cases, counter cases, my lord. It is between uncle, my lord, 2 brothers and their siblings. The clash is between 2 brothers and their siblings.
Where is the FIR?
FIR copy.
Where is the victims evidence?
My lord,
PW?
PW2, my lord.
PW2.
PW12.
PW1. Two victim.
Victim, my lord, husband, my lord, Norris Burman. All 3 persons injured. PW2, I have phlegma, my lord.
So this is injured is Sumitra.
Norris
Norris Burman, my lord, and
No,
Ponsavi
this is
Burman.
injury report of whom? Norris Burman.
Norris.
Okay.
Norris Burman, my lord. His injury is a grievous in nature, my lord.
Evidence of murder কথা বলছে
তো মারিছে বাকি কিতে মারিছে না?
So according to this PW1 is, what is his name?
PW1 is
Panchami Burman.
Panchami.
Okay, she is eyewitness.
My lord, three eyewitness, my lord, along with my lord, all of
Okay,
them.
she is eyewitness.
My lord,
Now,
PW,
according to her, she was beaten up mercilessly, this, that, what not. Okay.
Many things, so many things.
PW,
Then where is the victim? Victim statement? Huh?
PW2, my lord. will say.
PW2.
That is the husband of PW1.
So that he was in hospital, he was bleeded, then it was referred to the, what you call it,
BBR.
Dhubri. Nothing is there in medical. Man.
Interestingly, he says that he was treated at BBR. BBR is the name of a local hospital.
Maybe hospital. Look.
No one from BBR came.
And the injury they have described is nothing is there in the body.
my lord, but injury report is there, my lord.
Where is that?
Injury report is there, my lord.
Medical report of Naresh
My
Burman. Where is that injury report?
That's Burman, Panchami Burman, all of them. I have taken in LCR, my lord. And moreover, 3, 4 also independent eyewitness, man.
No, that we understand, but the way he was beaten up according to
My
his
lord,
wife and
injury report
him,
is there.
where is that?
Like my, I have taken.
Injury report, no? Eyewitness, PW6, PW10, PW, medical evidence. Medical evidence is there, where is that? One phlegmatic is FIR, one is seizure. What was seized?
My lord, that was
Rod.
rod, bamboo stick.
Bamboo stick was Naresh Burman.
No FSL to connect bamboo or
Mhm.
this rod with any of this appellant. No FSL, no fingerprints,
Oh,
nothing.
nothing is there. PW2 victim, PW eyewitness, PW6. These are the flags.
Hopefully, no injury.
That's injury.
Just
Ah,
put it.
come on.
I will come back. What is the maximum punishment? If 323?
23 is, my lord, could be,
Maximum and minimum.
yes. 323, yes, my lord, may extend to 1 year. For a term which may, there is no minimum punishment,
Extend to 3 years or
1 year.
extend to 1 year.
1 year, or with fine which may extend to 1,000 rupees.
Or
Or-
it is or.
Yes.
So it can be fine also.
That is precisely why I made that argument.
Give me a handle some judgments. How will we? And under what? Why should I give you that give you that benefit? I cannot my own whims and fancies say that okay, forget
No,
about
I
it.
go.
I'll have to give a reason. But give a even handle.
My lord,
Even handle.
your lordship probably, my lord, wants me to give some judgments which shows
Ah,
that once
ah.
an appeal is pending for over more than 10 years.
More than over and more particularly in backdrop of this kind of evidence instead of
Going
or
for
that you are
imprisonment.
arguing that these are the evidence after Swenso. So since 313 is there, but actual impact is not available. So therefore it will be an harsh.
Absolutely.
Only on sentence.
Only on sentence.
Give me something so that I can immediately convert it to
Tomorrow 2 o'clock.
My lord, here is the medical report. I have found.
not
all
2
the-
o'clock. Tomorrow at 10:30.
Tomorrow 10:30, absolutely.
এখন
Heard in part, list this matter tomorrow. List this matter tomorrow. You make a mention. I will take it as a first item.
I'm sorry.
This is no.
That is regarding my lord. Naresh Burman.
So why then, if it is then grievous, then why this court has taken it to be 323,
My lord,
both the courts?
for the courts, my lord.
What is the reason? If
Right.
323, why does that, if 320 is established, why this sentence is reduced? You take out that part of the judgment.
Absolutely. Thereby, other way also, there is no cross appeal, my lord. So that has.
That's what I'm saying.
There is no cross
So
appeal.
court has concluded it is not to be a, this court
320.
rejected this opinion, meaning thereby.
Hello.
So if that is rejected, why rejected? If rejected, why not converted into fine? That's all. You understand?
Yeah, I got it.
Otherwise, we'll have to enter into all this and then maybe not necessary. 5 minutes are coming. Process is continued.
No,
Huh?
no stall.
But Mr. Kama says already 9 witnesses has been examined after this order.
But I have no idea, Lordship.
That is why we have called you. He says that though there was an initial stay, by virtue of that judgment, Honorable Apex Court judgment, that was got vacated, and therefore the trial court proceeded. Already 9 or 10 every witnesses has been examined.
Take instruction then.
So if that be so, should we proceed in this matter or not? Mr. Kama says no, there then also a total 100 witnesses are there. So therefore we should proceed for this.
About Supreme Court judgment, I have no knowledge, Lordship.
No, not Supreme Court judge. That's Supreme Court judgment that what was that?
That infrastructure.
By virtue of that judgment, trial court proceeded. And 9 witnesses have been examined.
Even then, this petition will have to be disposed of because they have sought passing for a charges FIR.
Charge sheet or discharge?
Discharge.
Discharge.
Discharge, yes.
So charge has already been framed and trial has proceeded. Should we proceed with that matter, or if you say that no, Lordship can still argue, because Mr. Kamar is saying that 100 witnesses are there, only 9 and 10 are examined.
Let me take instruction then. The matter will be fixed thereafter tomorrow. I'll come to prepare with all the instructions.
Because that might have also some relevance in this case in the meantime. Now, the prima facie satisfaction of the evidence or not evidence, materials for a purpose of 227 to 28 has gone beyond that. Now, it has come in the form of certain evidence on evidence. Now, while dealing with this, sir, should we look into that or we will have to ignore it? Brass aside, forget about it. But if it is in his favor or even if in your favor, then what will happen? So it has now went ahead by virtue of time. So that you will have to enlighten us first, then we'll proceed. What do you say?
It will be taken up on Tuesday next. I'll take the instruction.
When
first.
can we take it up? 29th. See, we have no problem taking it up, but we do not want to waste judicial time, that's all. Since you are not aware. Okay.
On 29th, my senior will be in out of state.
Okay, give a date.
It will be 2nd of December.
2nd of December. Fine. On the prayer of Mr. Aloy, Learned Standing Council for the Learned. You are PP, na?
Special PP.
Special PP. Don't write Standing Council. Earlier it was Standing Council. Not, it cannot be Standing Council. Special Public Prosecutor for the CBI. Request for an adjournment. Matter stands adjourned. List this matter on
To take instruction, let it be.
to take instruction whether the matter had already proceeded in the trial court and evidence has already been taken. In as much as in the present case, the order of framing charge is under challenge. Full stop. List prayer is allowed. List this matter on 2nd of December 2020.
I think in this case, Halu is appear on behalf of the council.
Okay, yes, Mr. Haloy, Learned Counsel submits that Learned Special Public Prosecutor for CBI submits that he cannot argue this matter on behalf of the Central Bureau of Investigation as he was the petitioner in this case earlier. Accordingly, counsel for the petition, earlier counsel for the petitioner. Accordingly, he for an adjournment on behalf of the CBI so that the CBI can make alternative arrangements. Prayer is allowed, please this
4 weeks,
matter
after 4 weeks.
after 4 weeks. No, he's not aware of anything, so he says that I, 2nd of December.
My lord, that's true, my lord. This is that very case, my lord, wherein I was the successor of Baldev Malakar.
Oh, acha.
Rest is history, my lord.
Rest is history. I am nowhere involved in this case.
Knowledge is there.
Knowledge is something, not knowledge about the subject matter.
No, no, apart from the
Knowledge
subject.
about who will argue this case. Yes.
That's true, my lord. Much obliged.
Yes, whatever, what is this?
Yes, petitioner is convicted under section 406.
40?
406.
The
1 year.
present petition is filed. This criminal appeal,
Criminal revision petition.
assailing an order dated, a judgment and sentence dated. It was upheld by both court.
Yes, ma'am.
Judgment and sentence dated
My lord,
15/12/2019 passed by
no, my lord,
passed
15.
in listen GR DBB 123/2002, whereby the appellants were convicted under section 406 IPC and sentenced to undergo simple imprisonment for 1 year and also to pay a fine of ₹500 for 1 month. The further challenge is a judgment and order dated 22/9/2010 and 7/10/2010 passed in criminal appeal number 15/4/2009, whereby the aforesaid appeal was dismissed with modification of sentence by reducing the imprisonment to modification of the sentence. Okay, fine.
Reduced to 3 months.
1 year to 3. I will not say anything.
Yes.
Full stop. None appears for the revision petitioner on call. Accordingly, this court, where is the list? Since ultimately it's a right, na? It's
Yes.
not like a quashing and all. Accordingly, MS M. Bormon is appointed as amicus to assist this court. Let the record of the file be furnished to. Let the papers be furnished to MS M. Bormon and list this matter on 6th of December 2024 in the order column reflecting name of MS Bormon. Mr. Bhattakur, inform.
Yes, yes, I will.
Lordship, my senior is out of station.
Who is your senior?
FKR Ahmed.
Huh?
R. Ahmed.
What is the issue? You are not aware? This Keshu Sheikh. What happened to Keshu Sheikh?
Initially, this criminal revision petition was earlier dismissed by Honorable Justice my Lord Rumi Kumari Phukon on 1/3/2019. Thereafter, my Lord petitioner moved one SLP before the Supreme Court, and Supreme Court has passed an order on 9/10/21, and matter is remitted back to the.
Where is that?
I have flag marked, my Lord, order of the Supreme Court and order of this Honorable Court. my lord.
Yes. This matter is pending since 2011.
Next week.
Otherwise, my lord, in the trial court, my lord, record,
Mm.
no deposition is available in the record of the witnesses, my lord. Only order of the, my lord, trial courts and the in deposition of the witnesses are not available.
Okay, LCR was called.
Yes, my lord, LCR is available, but my lord, I have first then, my lord,
It is seen. Can we pass this order that it is not there?
yes, my lord.
But I think LCR was returned back. LCR was returned back.
LCR is available, but my lord, those depositions are not available in the record. Witnesses.
Though LCR is available in the LCR is available, however, the depositions of witnesses
Yes, my lord.
are not available in this in the record. This
Deposition-
matter was earlier this previous criminal petition was criminal petition has been remanded back by the Honorable Apex Court to decide on merit to decide it afresh, and it is also seen that the present petition was dismissed by a coordinate bench by a judgment dated 1/3/2019. Said judgment reflects that the evidences of prosecution witnesses were dealt in that said judgment. So this court can presume that the depositions were available on record registry to verify.
My lord, 161 statements are also not available.
Registry to verify and and submit a report accordingly. Please this matter after 3 weeks.
Please hold on.
P. Bhattacharya name not shown. So MSP
Minor.
Bhattacharya.
MIK explanation cause list.
Where is that? P. Bhattacharya, MIK. She has missed it, or generally she doesn't.
Minor.
Just inform, though name of MS P. Bhattacharya, MIK school is reflected in the post list. However, he is not present. Accordingly, Metro Sense adjourn and be listed on. Listed on 5th of December. Yes, can anybody intimate? Why she is not?
I will inform. Perhaps missed it, minor.
But generally she.
Minor.
May please, your lordship.
Mm.
Lord, here this case, my lord, the petitioner is a divorcee.
Mm.
After 8 years of marriage, she was divorced.
Mm.
And initially she filed a petition under Section 3 of the Muslim Women Protection Rights Act.
Mm.
And in that case, the learned court below granted only mahar money of rupees 5,500, 501, and maintenance only for 4 months, per month 1,000.
Mm.
So sorry, 3 months. Maintenance. The period 3 months.
Months.
So there was no given fair provision. The Section 3 of the Muslim Women Protection Act provides that there shall be fair provision made during the period of Iddat period. So that was not done. Therefore, ultimately, the petitioner before lordship, he has filed a petition under Section
He or she?
125.
C, yes.
Under Section 125 CRPC for grant of maintenance. And the learned court below has granted my lord, the maintenance as a fair provision per month till her remarriage,
1,000.
1,000.
Ah.
And that was challenged by the rival party.
Hmm.
And on revision, the session court has set aside the order.
Why? What is the ground?
Ground it has been quoted by Section 3 of the Muslim Women Protection Act. There is no provision of maintenance. And
So 125 is not be given.
no, yes,
That is the ground.
that is the ground.
Yes.
No. So for quantum is concerned, I have no any argument. So far, the
No, quantum means that has also been set aside in your revision.
my lord.
What is the ground we want to know?
Ground, my humble prayer, your lordship, kindly peruse page 77
No,
of the.
please tell us. We'll go in detailed hearing. Please let us understand the fundamental things first.
For section 5C cannot invoke the 125 without taking option, my lord. He has to take option, board have take to option, my lord, to proceed under section 125. That option was not taken, my lord. That was the ground, my lord. And while
Option is to be taken from where? Is it a position?
section 5
No,
says like that, my
did
lord.
she file an application under section 125?
No, my lord. She originally filed under section 3, my lord.
That is said that was
During pending,
dismissed.
my lord, that was suppressed, my lord. Then again filed.
No, that was dismissed or suppressed whatsoever. That she did not get any relief in that petition.
My lord.
So she files an application under 125. Is it a correct position?
My lord, she has to.
Don't go to the merit. Please tell us the facts. She filed an application under that provision of Muslim Marriage Act, which was dismissed.
It was not dismissed, my lord.
That was a limited priority for 3 months and
No,
something was.
that was not.
You have
dismissed.
said
That
The
was not
only
dismissed, my lord.
maintenance-
My
For
lord,
this
my
period-
lord,
Only
that,
the period.
my lord, that petition was converted into 125. London Ministry,
No,
my lord.
no,
That is the case, my lord.
no, man.
Not dismissed, my lord.
My lordship may
That was
kindly have a look
suppressed.
at the
that is what I'm asking. See,
It was.
he is saying whether that decision is right or wrong will come a little bit
My
later.
lord, my lord, my lord.
My first question is what he says is that initially an application under that Muslim marriage and so on and so forth was filed. He was granted only maintenance in terms of the SEDAC for a limited period.
the period.
In
3
that
months.
petition, that was not granted, my lord.
Huh?
In under section not granted, my lord. As you see, it
Okay,
was-
okay.
when
So
converted, then, my lord.
you say that was not granted. Then according to him, he files an application under section 125.
That
In
is
which
correct,
case magistrate granted him a amount of rupees 1,000.
my lord.
Which has been challenged by you in Sessions Court. Sessions Court has dismissed it.
My lord,
Ground will come later on.
my lord, my lord.
Is this fact correct?
Yes, my lord.
According to you? This fact is correct.
Correct. My humble prayer, your lordship, just to peruse the whatever.
So
the-
now we'll come to
My
that
lord.
these facts are correct.
Correct.
Now what is the ground therefore? I am asking that. Rejection, dismissal,
Ground-
total non-granting.
My lord, first, my lord, my lord, they, as per section 5 of the MW Act, my lord.
Hmm.
She cannot invoke the section 120 against her husband without invoking section 5 of the Muslim Women Protection Act, my lord.
Hmm.
That was not of the, my lord. Such thing, my lord. That too, my lord, before my lord,
What the
appearance.
law says, Mr.
My lord, the Supreme Court in many judgments says that Muslim
Muslim marriage is
not in contrast to the section 125.
125 and 125 and in independent procedure.
My lord,
It is a neutral secular law. Secular law,
Right,
therefore
right.
125 is maintainable.
Right.
So Metarans,
Only thing, my lord, before 125, they have filed, my lord.
no, that they have filed. So is it interlinked? That is to be answered, whether it is interlinked.
Whether it can be converted, my lord, without taking option. Section 3 of the Women's Protection Act, my lord, to 125. And that
Okay,
is
so according to you, it has been converted.
Converted.
According to him, it has been separately filed.
My lord, 125 is separately filed,
Okay.
but the learned
Okay, Lineate Court might have, your case is that Lineate, I have filed separate application. He has converted it. That should not, it is not my fault. Therefore, I should not be deprived of sub-property on this technical ground.
that has been the judgment of the Latifi judgment has been also.
Where is that?
My lord,
Judgment,
the
impugned judgment,
of the magistrate, my lord.
a magistrate
125, that is Annexure 4,
is
page 67. This judgment has been challenged by the other side, my lord.
is
Page
67, my lord.
Now,
Except
what is
two.
the present position of the parties?
So far, my lord, my trial is submitting, my lord, 13 years back, my lord. One hotel boy came to me bringing this respondent, my lord. He was a super intention cleaner, my lord. That time I took the my lord as a charity, my lord. Thereafter, no contact with me, lord.
Now you still
No.
still do the charity, will
lord,
decide on the law point.
only my lord, once he informed that she got married after 2.5 years or 2 years like that. I don't have any evidence, my
Well,
lord.
observe,
He also not evidence,
we
my
do
lord.
not
he
know
no-
what, you also do not know the position.
That
How
trial
would
is
you
submitting,
know?
we don't know.
You
my lord.
could not give any relief to the petitioner on the day one. He has given the relief the petitioner on the day one. In the meantime, you say both are separated. Nobody is having interested. But judge cannot take under 480 to 397 all these facts until and unless
Lord,
somebody files an affidavit.
Just to-
So we'll decide on merit.
No, sir, just to
That is my
respect, just to respect in the court, my lord, since it figured in the court,
Understand,
my lord, I have
understand,
come, my lord.
understand.
No contact at all.
So you do your charity for this court also for some time. We are not deciding it today.
My lord,
Just I want to understand the
only my humble prayer, kindly the order against whom they have come, my lord. As page 77, he paid my lord.
that is that is where I am.
Otherwise, it will give a wrong signal to the others, my lord. Not onto quantum and all, my lord. It is a meager amount, my lord. I must admit, my lord. I am not disputing that, my lord. But so far, it cannot be a wrong interpretation, misinterpretation.
No,
my lord.
that's why I'm not taking up this matter. I want to go a little bit.
Only humble prayer, kindly peruse the page 77.
This may be amount may be 1,000, but there is a view expressed by the judge. So
My lord,
if
my
we
lord, my lord.
differ with that view, we'll have to give reasons.
My lord,
Isn't it?
my lord.
And that this subject matter is, I am also not so thorough that this
Lordship,
provision,
lordship.
permission, this, that. So I want to go through.
No, lordship.
Yes, where is that? Okay.
My lord, my friend is, my lord, more interested to go through the judgment of this.
Not interested,
session
against
court.
whom
No,
he
not
has-
interested.
Not
He is
interested.
having no personal interest or clientele interest.
Yes,
also.
my lord.
Don't
Not
say that.
interested.
Don't say that.
My lord. Then, my lord, I want to refer the judgment of the magistrate, my lord, at page 67, annexure 4.
Definitely, Your Honorable.
So he has framed an issue whether a divorced Muslim woman is entitled for alliance under provision of section 125 CRBC.
Right.
That has been because here there is a divorce in the meantime.
Yes.
Isn't
No,
it?
it was after divorce, my lord.
Huh?
It was after divorce.
Admittedly after divorce. It was filed admittedly after divorce. So that issue will have to answer it.
My lord. Paragraph 2 of the judgment, my lord, in page 68, the second party appeared and filing WS inter alia stated that the first party was his.
Lordship will peruse both the judgment, my lord.
No, definitely. Without perusing, how can we go
My lord, that
decide?
is my submission, my lord. I don't have any other submission, my lord.
My lord, may I?
You will just support or may you instead of supporting you assist us.
Lordship.
Okay, you assist us that what
Lordship.
should be the correct position of law.
My lord, very simple, my lord. If lordship go through
Yes,
this,
tell us.
everything will be clear, my lord. Paragraph 2, my lord.
Mm.
The second party appeared and filed WS inter alia stated that the first party was his legally married wife,
Mm.
who was subsequently divorced by him, and for that the first party filed miss case number 1501 under section 3 of the Muslim Women Rights Act 1986. The case was disposed of on so and so in favor of the first party, whereby she was satisfied receiving the amount of then mohar maintenance for the period of iddar and getting back the gifted articles. The second party thus stated that this case has no merit and liable to dismiss. That is his contention, my lord. Paragraph 3. The factual position of the case is that the marriage is admitted, the evidence is also admitted, divorce is also admitted. Relief under section 3 of the Muslim Women Protection of Rights on Divorce Act 1986 as granted in miss case number so is also admitted in evidence. After divorce, the first party is not remarried. That being the factual position, the arguments were made centering in the following questions: whether a case under section 125 CRPC can be converted to a case under section 3 of the Muslim Women Protection of Rights on Divorce Act 1986, whether the first party having got relief under section 3 of the Muslim Women Act in her previous case has legally waived her right to get any further maintenance under the same act. If not so, what will be the quantum of maintenance? In support of the case of the first party examined herself, no evidence is, however, adduced by second party in support of the case.
In the learned counsel for the first party has cited a decision of our own High Court reported in 2005 GLT 107. He also relied in Sarkar CRPC page 245. According to the learned counsel for the first party, though the case was originally filed under section 125 CRPC, but it can be converted to a case under section 31A of the Muslim Women Protection of Rights on Divorce Act. It is further submitted that the decision of earlier case of the first party under same act cannot be bar for getting any further relief under the same act. On the contrary, the learned counsel for the second party submitted that this case is not.
Okay, Mr. Sikdar, we are fixing a date. Hard in part, list this matter for further hearing on. Yes.
Okay, this is my only submission.
Yes,
Lord.
yes,
It
I
may be different, my lord.
understand your position. When? 4th of December.
Obliged.
Yes, Mr. Chaudhary. How much time? And what are the issues?
Much time, my lord.
Issues?
323 only fine has been given.
323 fine given.
And
How much?
And already I have paid the fine, 1,000 rupees. But only thing is, my lord, they are government servants. So only whether, my lord, that could be converted to provision offenders act. And that's stigma in the section 12, my lord.
Give us handle. We'll do that. Give us the handle. If are not today. Musumi, give this matter on Wednesday. We have fixed one matter tomorrow, asking the lawyer to give us handle so that 3 months to fine. And in your case, fine already paid, whether that can be being a government servant. Give us that.
They are also, I think, already retired from service.
Okay, let him have an happiness. Yes, support, give us the handle. If possible, or we'll close it that everything is done, no, we are not entering. Okay, so give us a handle day after tomorrow, Wednesday. Possible?
13, madam.
13.
Obliged.
As a first item. Yes, Mahmood.
In this case, I was,
Okay.
if he starts.
No, we'll not continue. We'll fix it. You have been engaged in which case?
At 20 euros, item number 20.
Okay.
19.
20 or 20, no.
No, I think in 20. So you are in one case, he's in one case. So earlier some lawyers were there, now we have been engaged today.
If it can be taken up on 12 euros.
Oh, no, we'll take it up to 12. This month is totally packed. This month we have almost make out a plan. I think those no slot in this month. So since you have been engaged yesterday, we'll fix it in the month of December. Fine? When? Give a date.
Second week of
Because this is a matter of 2011.
22 years.
This is against conviction.
Conviction.
What is the conviction?
3 years.
3 years. Under section?
409.
Huh?
409.
Who are you?
I am the, your lordship, sir, district agricultural officer, your lordship. I did-
And you are?
Accountant.
What is,
UDA, come accountant.
what is the misappropriation?
5 lakhs and odd, your lordship.
Both the courts.
Both the courts.
So be ready ready to show the perversity. Will not go the one and its individual evidence. If necessary, we'll reappreciate. If you can prima facie show that yes, this evidence is on the basis of this evidence, a person cannot be convicted. A reasonable man would not convict. Then we'll go inside. Prima facie.
There are recursive material, your lordship, based on which probably.
Provision may be granted. That is.
What provision? He is
Not
arguing
a
for
provision, your lordship. In fact, your lordship, my argument will be on the point.
for
of
acquittal.
acquittal on the point of sanction, number one, your lordship.
Ah.
Number two, your lordship, my case is that, your lordship, even accepting every evidence, your lordship, they have produced, your
That
lordship,
should be the ground. In a revision petition, nothing but that can be a ground.
accepting everything, your lordship, it is a case of, for disciplinary proceeding, there is no criminal intent at all, your lordship. That's my case. Your
Okay, so you say that on the basis of that, there may be wrong decisions, negligence and wrong decision, but criminality cannot be attributed. But he is saying probation.
No, that is the last of all.
He is taking a, don't, the moment you express your last option, we understand. And we think the whole matter in that way. You are not having confidence that this is a good case, as Mr. Bhattacharya has expressed.
Those things are there, but considering the old days, all.
No, that cannot be. See, when,
And in fact, your
see,
lordship, what has
a
happened-
person's reputation is a very important facet of his life, isn't it? So, if really that has been done, we'll reverse it. But the reversion principle in a revision is also in a different standard, not in as a first appellate authority. So, we'll exercise first, we'll have to understand that this is a case where even we can exercise this power and even go for appreciation evidence. These are,
In fact, your lordship, two of us are, your lordship, charged, your lordship. If your lordship, that will have to be, your lordship, brought on accord, and your lordship, we will find that there's the conspiracy angle is not there, your lordship. Unless conspiracy is there, your lordship, we cannot be charged together, your lordship.
that's
That is also there, your lordship.
okay. You open your argument. On when?
Second week of
9th of December.
Deeply obliged.
It is submitted by Mr. Bhattacharya, learned counsel, that he has he has been engaged in this case yesterday only, and therefore he needs an accommodation to properly go through the records and argue this matter. Prayer is allowed, list this matter on 9th of December 2024.
Deeply obliged.
Please, your lordship.
Yes.
Lordship.
What is this case?
Lordship, we came up for enhance the punishments, your lordship.
To enhance the punishment.
Yes, Lord.
What was the punishment?
Punishment, they are released on provision of offender act, your lordship. Provision on probation, your lordship. They are held guilty under section 384 and 34, your lordship.
What is the what is 384?
Lordship, extortion, your lordship. Punishment for extortion, your lordship.
What is the punishment, total punishment?
Whoever commits extortion shall be punished with imprisonment for either execution for a term which may extend to 3 years, or fine, and or with fine or with both, your lordship. The lord, it's a kind of extortion put here on.
What was the demand of extortion?
The extortion was 3 lakhs, your lordship, but we have. We handed over 50,000. 3 accused persons were in the court red-handed, your lordship. They demanded the money in the name of BLT, your lordship.
What is your argument?
It's a clear cut of your lordship.
Why this order is bad?
Extortion. It's a heinous crime, your lordship.
Ah.
In the name of BLT, they put me in fear,
Hmm.
your lordship. Can it be? Can them stand?
Don't ask question, answer.
Yes, lordship.
Don't ask question.
It cannot be. This kind
Cannot
of
be.
offense-
Show us the principle of law. What is the parameters for exercise of power under this act? Show us that this is the parameters where, according to you, the prosecution has been able to establish
Yes, lordship.
beyond reasonable doubt.
Yes.
That findings is not under challenge. Now your only challenge is that this person could not have been allowed, granted the benefit of the provision of provision
Yes.
of Offenders Act.
Yes,
So
lordship.
therefore, you will have to first show us what are the principle of law under the said provision can be used and applied. And that this is not a case where it should not be applied. You are asking question, can it be given? We do not know. You show us that it cannot be. You don't ask question, you answer it that it cannot be.
Yes, lordship. It cannot be, your lordship.
It cannot be, show us why cannot be.
Heinous crime, your lordship.
That is your argument.
Yes, lordship. And lordship, this kind of offense, your lordship, allowing them on probation, your lordship. At least line trial court may call for a report of the probation officer, your lordship.
What was the provision? What is the provisions? When can it be granted? And why this case was not fit to exercise such provision?
Section 4 of provision of offender.
Yes, what it says. Have you read it? Now you are reading it for the first time in the court.
Yes, that's really.
Huh? You are reading it for the first time in the court.
I read it, your lordship.
Huh?
Read it, your lordship. Lordship, when any person is found guilty of having committed offense and not punishable with death or imprisonment for life, or not court by which person is found to be guilty is opinion that having regard to the circumstances of the case, including the nature of the offense, and the character of the offender, it expedient to release him that provision of good conduct, that notwithstanding anything contained in the other law for a time being in force, the court may, instead of sentencing them once to any punishment, direct that he be released on his entering into a bond without surety to a fear, and receive released on his entering into a bond with or without sureties to appear in receive the sentence when the call upon during the period of extending not 3 years, as court may direct and in the meantime to keep the peace and be good behavior, provided that the court shall not direct that release of offender unless it satisfied that the offender or his surety, if any, has fixed place and abode or regular occupation in the place over which the court exercise jurisdiction, on which the offender is likely to live during the period of which they enter into that bond. Before making any order under this section 1, the court shall take into consideration the report or report, if any, or the provision offender concerned relation to the case. Here in the lordship, 4 subsection 2, your lordship, they may call for a report lordship.
Then
That's all, your lordship. It was clear case of your lordship, 385, but the land trial court has taken cognizance on that 384, your lordship. and the Your Lordship Lion Trial Court not recorded any reason for releasing them for provision.
Yes, Mr. Nothing is there. Can a probation be granted in that manner? Huh? I'm happy, give a probation. Where are those satisfactions? Any judgments? Young counsel, you are getting chance there, you don't have anything, any research, anything. Very pity situation.
I have it to them, but I have not gone through it in this loss. I'm sorry for your loss. Your Lordship, 2005 for SSC.
What it says?
Chapter 22, the offender can be released on the probation of a good conduct under this section when the court forms an opinion. And having considered the circumstances of the case, the nature of the offense, and the character of the offender. Your Lordship, there is no any opinions, Your Lordship.
Phase 2. Six zero five. 605.
Which paragraph?
22, Your Lordship.
Huh?
22.
This is an appeal or what? Appeal against that criminal petition.
Criminal revision petition, Your Lordship.
When we have fixed this matter, PM Chaudhury's case, 13th, list this matter on 13th. আপনি একটা জাজমেন্ট এটা লিখে রাখুন। হ্যাঁ ঠিক আছে। ठीक है ना लगे। Okay, after tomorrow. Bablu versus State of UP. Supreme Court judgment na কি আছে? Bablu versus লিখি রাখছেন দেড় লোক উলিয়াব দিও। এলাহাবাদ হব লাগে চাই লও। Day after tomorrow. There is another matter we have fixed it. Huh? 13. More month to the 13.
My lord,
Keep
here,
this.
I am appearing as a legal aid counsel for responder 2 and 3, my lord.
Ah.
My presence may be recorded, my lord.
Hard. Swencho. Also hard Mr. Swencho, the legal aid counsel, Psychiatric legal aid counsel. Is this matter for further hearing on? 13/11. Yeah, okay, in the file of 18 Yes, ask anybody is interested.
Mas-
But difficult. This is not the way. Yes, Mr. Bhattakur. This is not the way to grant probation.
Such judgment that only because of the unless convicted under section 3.
Therefore, that cannot be. It is have to have a satisfaction. What is the purpose of this act? Why these are the conditions satisfied? And this in the given facts of this present case, I am happy or satisfied that this can be granted. This power can be exercised. Therefore, I have accordingly exercised. There must be reason that will give many situations. So suppose we interfere with this order. What next? We cannot interpret. Only we'll have to say that let him consider this part afresh. We'll have to remand it back. We cannot say to convict them because there are something why applied. So we'll remand it back for that purpose, including the consideration under of X. Having satisfied and by duly following this process. It is tentatively what is in mind. Yes, what are the other methods? Anybody interested? Huh?
I'm appearing.
22 interested. Okay. 22 interested. What is this, Mr. Sir?
My lord, the learned CGM, my lord, convicted the accused, my lord, under section 341 for a punishment of 1 month, my lord. And under section 325, my lord, for 1 year. Thereafter, my lord, on appeal, my lord, the learned additional session judge FTC Bongayo has reduced, my lord, acquitted under section 341 and reduced from 1 year to 6 months, my lord, under section 325.
What is the ground of challenge?
Basically, my lord, from the same incident, 2 FIR filed, my lord.
Okay.
First FIR filed by my husband, my lord. And that was, my lord, they have acquitted on the point of the delay of filing FIR, whereas my FIR was, my lord, first filed. In the similar you said, my lord.
Same incident arising out of 10th conflict. So that FIR, it was you were convicted. So your argument would be, in fact, if that is gone on delay, this ought to have also been gone on delay because this is subsequent in point of time, and both ways not analogously tried.
Yes.
Who is for the other side? PP. Okay, today we are not deciding all these matters. We are giving a date, Musumi, this month only. Huh? These are short matters. It will not take time. It will like orders matters only, not that we'll have to read it. That's why I'm asking what are the matters and accordingly, 21. 20,
my lord.
20.
19.
28 of 19. Guess this will not take much time. 20. Bhattakur, you will also see that provision that what will happen in circumstances. Suppose you allege he has beaten you up, he alleges you have beaten you up. Your FIR, both FIRs are surseated. In your case, it is said that acquittal was granted on the ground of delay in lodging the FIR, whereas his FIR is at a subsequent point of time. What will have the impact, please? Any judgments on that
Yes,
point?
my lord, judgment is there.
Yes, there.
And my lord, the section is also there, 223. What person may be charged jointly? The following person may be charged, person accused of the same offense committed in the course of the same transaction. And judgment is also, my lord.
Bhattakur,
Yes, sir.
find it out. You also be on. Yes, your method is?
24.
Public.
What is this?
Lordship may give a date and the month of December.
For CBI?
Yes.
Okay, when?
Any date, Lordship, December.
December.
First week of December.
What is the issue here? Are you aware?
Friday
Yes.
is not a
Lordship, the issue is with regards to the conviction of the appellant with regards to him allegedly possessing assets more than he should possess.
Okay.
Disproportionate assets.
Okay. PC Act.
See.
PC Act, it's conviction or charge or discharge? Discharge.
Lordship.
It is conviction after trial or it is a case of discharge? Oh, it's a
The-
criminal appeal.
Yes, Lordship.
Conviction. Convicted for how many years?
2 years, Lordship.
2 years. Okay. When? 6th of December. But don't take adjournment on that day.
Of course, Lordship. Thank you.
Obliged.
Much obliged.
First, we'll finish up of this 11 matters. Then 12, 13, 14, 15. Then it will be the bracket of 16 to 19. Now it is 11 to 15. Okay, till December 11 to 15. And if we can finish up this before, almost 13 is gone. Up to 13 revision is gone. Now appeal starts from 11. Our target is to complete by December, at least 11 to 15. If not 15, 14, because these revisions will take some time. That's why you're understanding what is the actual issue, how much time it will take. Suppose it takes that we'll have to, Mr. Commerce matter, it will take some time if they argue. So that kind of matter will fix in one day. 23. Okay, we'll give a date. Because we are at, now it is 110, we cannot blame, isn't it? We cannot say that none appears. Okay, list this matter on 27th.